Welcome. Thank you for joining us for our free Thursday webinar. I'm Nikki Jovicic from LookUpStrata, and I'm also the Managing Director of Tower Body Corporate, and I'm your host for today's session. Now, today's Queensland webinar is all about Strata essentials. We're joined by two representatives from the Office of the Commissioner for Body Corporate and Community Management, Nathan Francey and Nikki Vardanega. And Nathan and Nikki will help us break down the key updates and practical tips every Queensland Strata stakeholder needs to know. Our presenters will guide us through important disclosure requirements for managers and service contractors, share insights into how pet disputes are handled, explain the mechanics of voting at meetings, including what happens when someone abstains, and introduce us to the new prescribed body corporate certificate, which comes into effect from August 2025. This is a valuable opportunity to hear directly from the BCCM and ensure you're staying up to date with Queensland's evolving strata landscape. The content of today's session is general in nature. It doesn't constitute legal or professional advice. And if you're dealing with a specific issue in your scheme, please seek independent advice before taking action on the information contained in this session. Now, this is a Queensland webinar, and any reference to legislation is, of course, Queensland-based and only relevant to this state. Now let's meet today's presenters. We've got Nathan Francey, who is the Principal Community Education Officer with the BCCM's Information and Community Education Unit. He's been with the office for nearly 3 years now, following 5 years in various roles with the Office of Fair Trading. Nathan works closely with owners, tenants, managers and caretakers, helping them understand their rights and responsibilities before matters escalate to formal dispute resolution. We were very fortunate to have Nathan join us as a presenter for our inaugural live event on the Gold Coast earlier this year. And if you've called the BCCM office, you might have spoken to Nathan at some point as well. And we've also have in the session today, Nikki Vardanega has been with the BCCM office for 12 months. She's had nearly 4 years experience as a mediator, and she brings a strong academic background in behavioural science and criminology. And she's passionate about empowering people to solve conflicts through respectful and constructive communication. So Nikki also coaches trainee mediators and strongly believes in the value of conciliation in building long-term resolution skills. So we very warmly welcome Nikki and Nathan. Thank them very much for joining us. So let's get started. Thank you, Nikki and Nathan.
Yeah, thanks, Nikki. That was a great introduction for us, and thanks again for having us. It's nice to do these things and make sure everybody knows. Just a brief overview of our office and what we do. So we've got our 2 sections there, our information and community education service. We provide general information, callbacks and written responses to any questions that people may have about body corporates and living in one. And then the other half of our office is that dispute resolution service, so our conciliation and adjudication services that Nikki will go into more detail about being a conciliator. Just some fun facts about body corporates in Queensland: over 50,000 different schemes, 500,000 lots. And we usually get about 17,500 phone calls each year and about 1,500 dispute applications, which when you think about it, that's 1,500 disputes is actually pretty good for the amount of people that live in there. It seems like everyone does get along for the most part. And the locations, a quarter of them at the Gold Coast, a quarter in Brisbane, and the other half around the rest of Queensland. So mainly here in the southeast is where the body corporates are. And basically, this is just an overview of who lives in body corporates and who does what. At the top of the pyramid, you've got your owners. They're the main decision makers, the people that really have the power in the body corporates, closely followed by the committee that they elect on that second tier of the pyramid there, just to make the day-to-day decisions and run the scheme. And then you've got your caretaker and body corporate manager there on the third tier, basically assisting the committee and the owners with some tasks that they need, administration services, that sort of thing. And then you've got your tenants, your occupiers within the scheme that don't have that voting power, but are still, involved, need to abide by bylaws and can have access to the body corporate for any information that they may need. Your regulation modules, if you don't know which regulation module applies, that's the piece of legislation that comes under the Body Corporate Act. I do recommend finding out. You can look at your community management statement or ask your body corporate manager which one. They should be able to tell you. There's 5 different ones. So we've got the standard module takes up majority of it. And then your accommodation module and your small schemes module are the next two common. But yeah, definitely find out which one you are if you don't know, because it does answer a lot of your questions. And if you contact our office for anything, that's the first thing we're going to ask, is which regulation module applies. Now, a big topic at the moment is disclosures, commissions, benefits, and disclosures for both body corporate managers, caretakers, and committee members as well. When in doubt, just disclose anything that you may be not sure about. So if a body corporate is considering entering into a contract, or they are one and it may be up for renewal or extension, and you are going to receive a commission or a payment or a benefit, it could be anything. Even a bunch of flowers could be a payment, a gift of some kind. You must disclose that to the body corporate in writing. And if you don't disclose that, that could lead to some other problems later. You just don't want to be seen as, favoring any businesses over another, or I don't want to say bribes, but that is what it could appear to be. And the same thing applies for associates. Now, the legislation does define associates. In section 309 of the Act, it gives a list of people who can be associates. So if the body corporate is considering entering into a contract, you do need to just make sure that you're not an associate of that person, because if you are, you have the same disclosure requirements as the body corporate manager or the caretaker that could be entering into that contract as well. Some things to think about: you have to disclose any commissions or benefits that you receive. It's not a optional thing. You must do it, and it's very specific about that in the legislation. Our office has designed a new form that can help you to do that. If you just simply do a Google search for BCCM Form 35, you'll find it. It lays out everything that you need. It has sections for, what you've been given. If it's a monetary value, how much was it? Who you need to give that form to, and who needs to be aware of this disclosure, and when to make the disclosure as well. Like I said, if you don't do that, there can be some penalties. Currently, it's 20 penalty units if you fail to disclose. One penalty unit, I believe, is about $185 at the moment. So it is quite a significant penalty. And it also damages your reputation. If you don't make these disclosures, it can give your business a bad name. It could give you personally a bad name. And then it may cost you making other business deals in the future. So like I said before, if in doubt, make the disclosure. There's nothing, stopping you from disclosing anything, really. If you aren't sure about it, if you disclose it and it turns out to be nothing, you didn't need to make that disclosure, but no harm done. You're just protecting yourself there by making everyone aware of what's going on. Just being transparent is the best way to go about anything when looking at signing contracts or extending contracts. We do have a bunch of resources as well that can help with disclosures. Now, I know that you're going to get a copy of these slides, so you don't have to write these down super quickly. We have a new disclosures webpage that outlines any disclosures that need to be made, who needs to make them, and when. You can always call us. We have our newsletter, Common Ground. Issue 46 specifically focuses on disclosures. So have a look at that, and I do recommend signing up for our newsletter. It's a great source of information. And there's also the legislation itself. So, if you like reading the legislation, feel free to look at those sections, and you can always go a bit more in depth and get the legal versions of it. I suppose we try and simplify everything on our web pages and in our newsletters to try and make it make sense to the regular person. But if there's any lawyers or body corporate managers out there that want that, those are the sections you can have a look at. Now, this was the topic of voting that Nikki told me that a lot of people have been asking about specifically, especially when it comes to people abstaining from votes. So our general meetings, your AGMs or your EGMs, ordinary resolutions are definitely the most simple. It's more yes votes than no votes. Count the yeses, count the nos. If there's more yeses, the motion's passed. If people abstain from that, you just don't count them. It doesn't change anything. It's simply more yeses than nos. If you've got 4 yeses, 3 nos, and 7 people abstain, doesn't matter. You got more yes votes than no votes, so that motion will pass. Special resolutions are a little bit different. Abstaining from votes really doesn't change the first 2 dot points there. You need 2 votes, 2/3 of the votes cast to be in favour of the motion. If people abstain, they're not voting in favour, so they don't get counted as votes for the motion. The number of votes against the motion can't be more than 25% of the total number of lots. Again, if people abstain, they're not voting against the motion, so you don't count them. You only count the no votes. If that's more than 25%, it fails on dot point 2, so the motion fails. And then the third dot point is where the abstaining can get a little confusing. It's the total contribution schedule lot entitlements of votes against the motion, not more than 25% of the total contribution schedule lot entitlements for all the lots in this scheme. So you're not counting the votes per se, you're counting the lots in the scheme. So if my vote, if I abstain, my lot is still counted as a lot in the scheme. I hope that makes sense. And then resolutions without dissent. If anyone votes against the motion, it fails. If I'm abstaining from the vote, I'm not voting no. So my vote is, an abstain is not a no vote. It just doesn't count. I'm not voting against it. And for all 3 of those, if I abstain from the vote, that gets recorded in the minutes for any type of resolution at a general meeting. I hope that clears that up a little bit for general meetings. For committee meetings, it's pretty similar. So at committee meetings, it has to be a majority of the votes of the voting members present and entitled to vote. That's important. But also of those that are actually voting. So adjudicators have previously ruled that abstaining from a vote is not voting. So, for example, if you've got 6 people on your committee, if 3 people vote yes, 2 people vote no, and 1 person abstains from the vote, the majority of that 6 would normally be 4. But if 1 person abstains, they're not voting. So that first dot point says on the last 3 words, who are voting. If you're abstaining, you're not voting yes, you're not voting no, you're not voting at all. You're just removing yourself from the vote. So that brings that majority down. Instead of 6 people, there's 5 people who are voting. So that majority goes from 4 to 3. 3 is the majority of 5. Hopefully that clears it up. And for voting outside of committee meetings, it's the majority of all members of the committee entitled to vote on the motion if they agree to the motion. It doesn't say who are voting. It doesn't have those same last 3 words that voting at committee meetings does. So it's the majority of all the members on the committee entitled to vote on the motion. So if there's 6 people on the committee, you still need that 4. If we'll do the same scenario, if it's 6 people on the committee, all entitled to vote, that's important. 3 vote yes, 2 vote no, 1 abstains. The abstaining person is still counted because they're an eligible person to vote. So it's slightly different for voting outside of committee meetings. It's the majority of all the members, not just those that are voting. And again, same thing, put it in the minutes so that everyone's aware of who voted how and who abstained. Body corporate certificates. So like Nikki mentioned, the new certificate is launching on August 1st. It's replacing the old one. So under Section 206 of the BCCM Act, the was a disclosure statement. That's being replaced by a new section in the Property Law Act, and they've got a new form. We don't look at the Property Law Act, so please don't ask me about it. What I can talk about is the new body corporate certificate, our Form 33, or 34 if you're in a 2-lot scheme, but that's not many people. So the body corporate certificate, we've tried to, I suppose, encompass everything that someone would need to know into one form. And the body corporate certificate can be obtained from the body corporate for a fee. It only applies to sales of existing lots, not sales of proposed off the plan lots. There's separate sections of legislation that apply to the off the plan ones. So the Form 33 is only for existing lots. I know that there is some questions about that and that we will cover at the end. So please feel free to send them through if you have any about that. The forms are now available to download on our website. We've just do a Google search, body corporate certificate, Form 33. Basically, we've put them up. They did have a watermark on them. We've now taken that off. So in preparation for August 1st for body corporate management companies or anyone that wants to just be organized, if you're a self-managed body corporate, you can now download those forms and start filling them out. It will just prepare you for any sales that happen early August. If you don't want to be rushed on the 1st or 2nd or 3rd of August, then feel free to download that now. And you can fill it out now. They just don't take effect until the 1st of August and won't apply to any sales that happen before then. And this is where I will hand over to Nikki to talk about pet applications and the conciliation side of things.
Yeah, thank you, Nathan. Hi, everybody. Next we're going to talk about pet applications. I'm going to talk to you about the new sections of the Act that relate to pet approvals, and I'm going to introduce a simple 4-step process to assist you when you receive a pet approval. So here's our mate Boxy and his pet dog. Pet approvals are not always straightforward, so he says follow these steps. Before we look at the steps, though, here is the new section 169B of the Act called Bylaws about Keeping Animals. It was added in May 2024. Please don't try and read the slide just yet. We will go through each of the 7 subsections throughout this talk today. Before we go through each of those subsections, though, the first subsection says that this section, 169B, bylaws about keeping animals, does not apply in relation to an animal that is a guide, hearing, or assistance dog. And that is because there is another section, section 181, which is specifically about guide, hearing, and assistance dogs. This shows the definition of who can have an automatic right to keep a dog on common property or in the lot, and any bylaw cannot overturn this right. We'll talk more about this section later in the session when I will introduce to you an example adjudicator's order that considered exactly this section and the definition of what is a assistance dog. So back to the 4 steps. Here are the 4 steps for an animal approval or a pet approval. The first step is to review your bylaws. The second step is to check if the matter is a reserved issue. Third, you will have written requests and written notices. So it's about keeping good records. And the 4th step is actually making a decision or the approvals process. Who can say yes, the options for saying yes, and the options for saying no as well. Next slide. Thank you. So step 1, reviewing your bylaws. When you go and review your bylaws, you'll want to look out for these 4 things specifically in regards to an animal application. You'll want to look at the animal bylaw and check if it is a permissive bylaw. So essentially, can the body corporate give a written approval to allow an animal on the lot or on common property? Perhaps it might identify that the approval is subject to conditions. The legislation generally allows for a permissive bylaw. You'll also want to look if it's prohibitive. So does the bylaw say no animals are allowed, or does it restrict the number or type of animal? It might be an unreasonable bylaw in that case, and the bylaws might need to be changed before someone can seek approval for an animal to be kept on the scheme. You also want to look at the specific wording of the bylaw. So bylaws come in all shapes and sizes. As a conciliator, we get to see a copy of animal bylaws. I can report they are, some are very simple and some are very complex and lengthy. So you need to look at the very specific wording of your scheme's bylaw, and it might indicate whether the matter is, for example, a reserved issue. So it might say the general meeting or all lot owners can make the decision, or it might specify any conditions that must be imposed or may be imposed when an approval is given. Linking back to the Act, Section 169B, subsections 2 and 3 are about what bylaws must not restrict and what the bylaws can provide for. So, must not prohibit keeping an animal on the lot or common property, must not restrict the type, the number, type or size of an animal, etc. So bringing it back to the new legislation change. Step 2, so once you've checked your bylaws, then you want to check if the matter is a reserved issue. So that essentially means, can the committee make the decision? The committee might not be able to make the decision, and you can find this information either in the wording of your bylaws, or you can find it maybe in a previous general meeting decision, so an AGM or EGM minutes. In that case, the approval needs to go to a general meeting. As you may be aware, considerable time and expense is often involved in calling a general meeting, calling and holding a meeting. So perhaps it is in the best interest of your scheme not to make this a reserved issue for the committee. So when animal approvals come through from tenants or occupiers or owners, then it can go to the committee for a decision. You can even make the decision by a VOCM potentially. You can change that if it is restricted. You can change it to an unrestricted issue by either changing the wording of the bylaw or making a general meeting decision currently to undo a previous general meeting decision. So the reason why it's a reserved issue is important because, as I said before, it impacts on what type of meeting is needed to be held, so that committee meeting or a general meeting, and also specifically it impacts how a deemed approval would work. Someone in our office made this fantastic flowchart overview of the steps required for pet approvals in a body corporate. You can find this flowchart along with a lot of today's information about pet approvals if you search online BCCM Guide to Animals in a Body Corporate. So there's lots of information. I think that's a new guide that we've uploaded recently. Go have a look at that after today. So step 3. Step 3 is about your record keeping. So the first part is the request to keep or bring an animal must be made in writing. So the applicant must put in writing to either the secretary or the chairperson in the secretary's absence, or a body corporate manager, if that manager is authorised to carry out some or all of the secretary's powers, must put in the request to keep the animal in writing. We do have a form, BCCM Form 31, titled Request to Keep or Bring an Animal on Scheme Land, or your body corporate might have your own internal preferred form to use, but ultimately it has to be in writing. The applicant should include as much information as possible in their application to avoid any unnecessary delays or disputes that can arise. Remembering that a body corporate has to make a reasonable decision, and that means considering all the facts and circumstances available to it at the time of making that decision. So if the applicant can give as much information to assist a body corporate's decision to push it over the line to say yes, that's really important for an applicant to do. The part 2 of record keeping, so this step 3, is the body corporate must give written notice of its decision. So written notice must be given to the applicant or the occupier as soon as possible after a decision is made. We have another form, BCCM Form 32, to help you meet this notice requirement. Any decisions must also be included in any minutes. So Nathan was saying before about minutes, and the votes yes and votes no and the abstentions, and that must be sent to all owners. And any vote outside of committee meeting minutes or deemed approvals must also be ratified at the next meeting. We will talk about deemed approvals in a moment. now that we're at step 4, we're talking about the approvals process. So you've gone through step 1, step 2, and step 3. You've checked your bylaws, you've checked it's not a restricted issue, or maybe it is a restricted issue. You then have your written process. So you've got a written application, and then you are effectively making the decision. So the last step, step 4, is the approvals decision process. If we look again at section 169B, subsection 4, it specifically says if a bylaw requires the written approval of the body corporate for the scheme or the committee for the body corporate to keep or bring an animal on the lot or common property, the body corporate or the committee must, after receiving a request for approval within a prescribed period, must decide whether to grant the approval, and may in writing grant the approval subject to conditions that are in the circumstances reasonable and appropriate, and must not unreasonably withhold with approval. The new section 169B of the Act gives examples of conditions that may, in particular circumstances, be reasonable. So 1, the animal must be in a carry cage. This is a condition example. Animal must be in a carry cage, in a pet pram, or on a leash in order to limit the animal's movement when in a lift in the scheme. And the animal's waste must be disposed of in a way that does not unreasonably expose another occupier or another occupier's invitee to the odour or sight of the waste. So those are some examples of what conditions may be reasonable, but it has to be in particular circumstances. So in one circumstance, that condition might be reasonable. In another circumstance, it might be unreasonable. We do see a lot of disputes come through conciliation and adjudication about approvals, reasonable or unreasonable conditions of approval, or if the body corporate just says no to the animal without giving a reason. While not necessarily a requirement of the Act, I do encourage you, if you are on a body corporate, to communicate your reason for saying no or imposing certain conditions. Open communication and dialogue can assist with resolving issues early before they become a dispute with our office. I would also recommend looking at previous adjudicators' orders before imposing a new type of condition that's not included in the Act or the bylaws to double check if they're reasonable in a similar circumstance. Okay, I've mentioned deemed approvals a couple of times. So this is also saying yes to an approval, and only regarding pet applications does not making a decision within a prescribed period automatically fall to a deemed approval. The magic number is 21 days. If the committee can make the decision, so if it's not a restricted issue and the committee can make a decision, they have 21 days to do so. If it is a restricted issue and a general meeting has to be called, the general meeting has to be called within 21 days, so the notice given out of the general meeting, and the body corporate has to decide within 6 weeks after the general meeting notice is sent out. If those timeframes fail, the pet is deemed approved. And most importantly, the body corporate, there are no conditions imposed. So even with a deemed approval, the committee should give written notice to the applicant, and there's sort of no conditions that would be imposed as a part of that approval. Step 4, so refusing a pet. The new section 169B of the Act also gives examples of when it is reasonable and unreasonable for a body corporate to deny a pet application. Firstly, it's now clear that it's not reasonable to deny a pet based on the scheme having a no pets policy. I have seen that a lot of older schemes tend to have this type of bylaw. If that is your scheme, you might want to go back to step 1 and consider changing your bylaws. There are a few cases where it may be reasonable for a committee to deny a pet application, very few circumstances. The Act gives under subsection 6 a couple of examples. So, for example, it can be denied if there is unacceptable risk to health and safety of occupiers and reasonable conditions cannot meet the risk or manage that risk. Or the animal might contravene a law, such as council regulations might have a limitation on how many animals can be kept inside a lot. So you might not be able to have 5 dogs inside a lot, for example. Or if a dog is a regulated dog, or if the occupier doesn't agree to the conditions imposed. So those might be examples of where it might be reasonable for the committee to deny a pet application. If you are thinking of denying a pet because of what might happen, so you're worried about barking, or there might be a nuisance, or the dog might be let off lead on common property, but it hasn't occurred. So it's a worry about what if might happen, that might be considered unreasonable. However, Section 7, so the very last section of 169B, essentially allows a body corporate to revoke an approval if the owner does not follow the conditions set. So, for example, if the person gets an approval from the body corporate and the person continues to not comply with the conditions imposed, you can revoke that approval, you can issue contravention notices, and you can raise a dispute with our office. So, last section of 169B, number 7 there. Now I'm going to talk to you about an example scheme. So Bayview Tower is a very interesting scheme that had a couple of adjudicators' orders about pet applications. The scheme has 2 orders that we'll discuss today. The first one was before the legislative changes in November 2023, and the second one is after the legislative change in 2025 this year. The scheme is interesting because of the design of the building is very tall. It's got a few lifts and several residents with serious health issues affected by dogs and dander particularly. So the first order was a dismissed application from the owner versus the body corporate. The owner was seeking the adjudicator to approve his dog in the scheme and had presented both the body corporate and the adjudicator with lots of information in his application. It was commended by the adjudicator, in fact, that he presented a lot of information, a lot of conditions to manage some of the risk to those other occupiers in the scheme that have health issues. The committee had also presented substantial evidence about the residents having health complications, aggravated particularly by dogs, and the committee had adopted a zero risk approach. So before we were talking about a no dogs policy is not allowed, but this scheme had adopted a zero risk approach to the concerns around the health and safety of the other occupiers in the scheme. In this circumstance, the applicant did not discharge the burden of proof that the committee's decision to deny the pet was unreasonable or that the conditions they had proposed would manage the risk adequately. However, this is a very unusual case, and the adjudicator also presented, so the adjudicator dismissed the application to approve the dog. The adjudicator also said that it could have been reasonable for the committee to approve the dog with reasonable conditions. A quote from the adjudicator said, "Unfortunately for the applicant, the committee took the former course." So very interesting case, that one. The second order that's come through in 2025 was made this year after the changes came into place. So this matter went through conciliation over a pet approval process, being denied by the body corporate due to taking that zero risk approach to other occupiers in the scheme. The adjudicator notes that based on the legislative change, the zero risk approach could now be considered unreasonable, especially where there is no evidence that the committee considered conditions that could be imposed to manage risk. So the committee hadn't considered imposing any conditions to manage risk. They just were maintaining their zero risk approach to no dogs in the scheme, essentially. However, this was a slightly different dispute. So the owners had revoked their pet application and instead decided to rely on Section 181 of the Act, which gives them an automatic right to have their pet on common property and in their lot, and the bylaws cannot restrict that. But they had failed to provide evidence that they meet the definition, that their dog met the definition of an assistance dog, and specifically that the owner had a disability and that the dog was trained to perform tasks to assist with the disability. That's what the definition of an assistance dog is under the Guide, Hearing and Assistance Dog Act. The body corporate took the owners to adjudication on the matter, and the adjudicator made a declaratory order, essentially that the animal registration notice that the owners had been given, that the dog Daisy is registration fee class of assistance dog, was not sufficient to call it an assistance dog. In these circumstances, the adjudicator said they don't consider that the respondents have any right to have their dog Daisy at Bayview Tower under Section 181 of the Act. It's interesting to me because if they had pursued the matter to adjudication on seeking an approval with reasonable conditions, the adjudicator might have been of the mind to say it was unreasonable for them tonight, but they changed it and went to Section 181 of the Act. So just an interesting order that came about this year after the changes to 169B. Thank you. That's it from me.
Okay, wonderful. Thanks so much. Thanks, Nikki. Thanks, Nathan. That was a fantastic presentation. What is regarded as a special resolution?
So there's specific things that are listed under the whatever regulation module you're under. So certain things need to be a special resolution. The best example is if you're changing your bylaws, that needs to be a special resolution. And then there's a lot of things to do with changes to your community management statement, need to be special resolutions as well. It just kind of gives that extra level of, okay, this is a serious issue and we do need more owners to want to make the change. Especially for like the pets issue. If you're changing your bylaws about pets, a lot of people have pets these days. So if you're going to change your bylaws to, you know, allow pets or put certain conditions on pets, a lot of people are going to want to have a say on that. So it just kind of gives that extra level of strength to that. Okay, 2/3 of our owners do want this change, so we need to make it. But yeah, like I said, there's certain things listed in the regulation modules about what needs that level of approval.
On the Queensland government website, under body corporate definitions, the definition of abstain is stated as when a voter chooses not to cast a vote on a motion either for or against it, no vote is counted for an abstention. So does this general definition apply across the Act?
Yeah, it doesn't. The legislation and the Act, it doesn't specifically say that. We rely a lot on previous adjudicators' rulings for a lot of the information that we give out. It doesn't say anywhere in the legislation that an abstain is a no vote or an abstain is a yes vote. So we do get a lot of people thinking, oh, if you abstain from a vote, you aren't voting yes, so we're going to count it as a no. That's not correct. It doesn't say anywhere in the legislation that an abstain is a no. And that's what adjudicators have relied on when making those decisions. And that's why we say on our website that an abstain it's not a yes, it's not a no. You simply don't count it.
Okay, wonderful. Well, we might give 2 examples that we've been provided. So one of them was a motion at a VOCM with 6 voting members has the following votes. So there were 3 yes, 1 no, 1 abstain, and 1 failure to vote.
3 yeses and 1 no for a motion at a VOCM. So voting outside of committee meetings, you need a majority of the voting members of the committee who are eligible to vote, being the key thing. If all 6 of those voting members are eligible to vote, you need a majority of them. So you need 4 yeses for a vote outside of a committee meeting. So if you've only got 3 yeses, 1 no, 1 abstain, and someone doesn't vote, you don't have a majority of those 6 voting yes, because you don't have 4. For VOCMs, you count the committee members that are eligible to vote. Do you have a majority? If not, motion fails.
Okay, excellent. All right, so that's that one. The other one was an ordinary resolution at a general meeting where there is a quorum of 10 eligible owners voting. The following vote was obtained. So there were 4 yeses, 3 noes, and 3 abstains.
Yep, so ordinary resolutions are the easiest one. It does not matter how many people abstain. 4 yeses, 3 noes, motion passes. You could have 100 people eligible to vote, 90 of them abstain. If you get more yeses than noes of those remaining 10, the motion will pass. That's all you need to worry about for ordinary resolutions.
Okay, excellent. Now, I think there's still a bit of confusion there because someone's just put a comment up regarding the first one that we answered saying they're not sure if that's correct. If you have one person choosing to abstain. So obviously there's still confusion out there. I don't know whether that person is a strata manager or a committee member. But yeah, we have certainly noticed in questions that have come in that even strata managers that have been working and dealing with abstain votes for a long period of time, there is a different opinion on how they're treated.
I think where the confusion happens is because VOCMs or vote outside of committee meetings VOCMs, because the rules are different for VOCMs as they are for actual meetings, for physical meetings, that's where the confusion can happen. Because if you've got, those same 6 people voting at a VOCM, it's a different rule for if they're in a room together and they all vote. If you abstain when you're in the room, you're not counted because you're choosing not to vote. So it brings the majority down one. So I think that's where a lot of the confusion comes from. But once you draw that line between, okay, VOCMs, they are counted, the person is counted, the abstaining is not. But at a meeting, the person's not counted because they're choosing not to vote. So there's different rules for VOCMs and committee meetings, physical ones. I think that's where a lot of the confusion comes from.
Okay, I think that's fantastic. And the person's just commented in there saying thanks very much for that clarification. I think that's that in their instance, that's where the confusion came from. If a pet application needs to go to a general meeting, who's paying for this? Because the managers don't work for free. And this is another question that we get asked a lot.
There's for sure, there's a few adjudicators orders that look at this. Basically, you can't charge a specific owner to have a meeting. The general meetings are body corporate meetings, and the body corporate pays the cost. So that money will come out of your admin fund or whatever body corporate funds you have there. Body corporate managers charge different things for different types of meetings, or maybe they have hourly rates, whatever. The costs are going to be different for everybody, but they are a body corporate cost if the body corporate pays it. And a lot of body corporate managers as well, we've seen, they charge an owner for lodging a pet application, even if the committee can make the decision. They'll say, oh, we've got a $75 pet application fee. That is still technically charging that owner to make a decision. So any decision that body corporates make, they are a body corporate cost. So the body corporate pays for it. You can't charge an owner.
Okay, wonderful. Thank you. And then we're also asked, can a committee member vote on their own application for a pet?
If they don't think they have a conflict of interest, sure. If they have a conflict that they declare, they're ineligible to vote. But again, it may not be a conflict, because if I'm on the committee and, both of the Nikkis submit pet applications, I can vote on their applications. Why can't I vote on mine? Yes, it's my pet, but if I'm going to treat that pet application exactly the same as I treat your pet application, I don't have a conflict. So it's up to the individual to decide whether they have a conflict or not. If you live in a really contentious scheme where your committee is always being criticized for making decisions they maybe shouldn't, you might want to declare that you have a conflict and not vote on that issue, just as a bit of protection. So it's up to the individual person, really.
Okay, thank you. And we were also asked, this is more to do with the disclosure. So what rules or codes of conduct apply to committee members regarding the selection of contractors?
So yes, they have to abide by the code of conduct for voting committee members, which is Schedule 1A of the Act. So if you're on the committee and you haven't read that, please do. But basically, most of it is just common sense, to be honest. If I'm on the committee and my brother owns a construction company and we're going to hire or I'm going to submit a quote from that company to the committee to make a decision, or maybe to a general meeting to make a decision. I know him and it might look like I'm favoring that. So I should declare that and be like, hey, letting everyone know this is my brother's company. It may be a legitimate company. They're good builders. It's a legitimate quote. There's nothing wrong with putting it forward. You can still submit it, and everyone else gets a vote on it as well. So there's absolutely nothing wrong with that. As long as you're doing everything fairly, honestly, and abiding by that code of conduct, there's absolutely nothing wrong with it. You just need to declare it.
Okay, thank you. And then just one step further from that, I guess, what steps can the body corporate take to ensure the quoting process is fair, transparent, and free from bias? And I guess that also includes making sure that if the quote has been submitted by the body corporate manager, what steps can the body corporate take in that instance to make sure that the quote process is fair?
Yeah, so with our new form that they can definitely use to make those disclosures, use that because it covers everything you need to declare. So definitely use that. Transparency is key in any of these situations. Just making everyone aware when you send out your meeting notices, your agenda, just put as much information in there as possible to make everyone aware. And if you give everyone everything that they need to know, even if give them things they don't need to know, as long as they have all of the information in front of them to be able to make an informed decision on how they want to vote, if you give them everything, they can't then come back and complain that they weren't told about something, or, you hid this from me, you're getting a commission from this person, that's why you put their quote forward. Just give everyone everything, let them know, be transparent. And at the same time, as owners, if you're not happy with the quotes that are being provided to be voted on by your body corporate manager or your committee, you can go and get your own quotes as well and submit them for consideration, especially at general meetings. All owners can submit motions for general meetings. Feel free to get your own quotes, put them up, and then all the other owners get to vote on those as well. So as an owner, you've got the power to do that. If you're not happy or satisfied with the quotes that your committee's got or your manager's got, get your own.
Okay, wonderful. So get involved in the process. And we might just cover off on the body corporate certificate as well before we go, because I know a lot of people were putting comments up in chat about that. So we were asked who holds and can complete the body corporate certificate. Can only the body corporate manager do that, or can the committee fill it in as well? And you've mentioned that you can download the form off your website as well, Nathan.
Yes, it's up. It's ready to go now. So you can download it and start pre-filling things if you wish to. I would say anyone can fill it out. If you're on the committee, maybe you might be a small scheme, you don't have a body corporate manager. So if your secretary, your treasurer, your chairperson, they all handle, all the business, the levies, everything like that, that's fine. They can definitely do it. I would think most body corporates that have a manager would just get the manager to do it. It seems to be the way that they do things these days. And also they have the systems that can fill it in, like Strata Max. You click a couple buttons, it'll automatically fill the form in for you. So it does just save a lot of time that way. But yeah, even if you have a body corporate manager, if you're a very involved person and you want to do it, feel free. Definitely, you can still do that. Your body corporate manager may be charging the body corporate for that sort of work. So if you're involved, you're the secretary or you're on the committee, you want to do it yourself to save the body corporate that money, great. Obviously check your contract and see what it says. But other than that, yeah, anyone can really do it.
Okay, and we were just asked who has the authority to actually sign it.
Usually it's the chairperson or secretary that's doing that. They may delegate that power to the body corporate manager. That's totally fine as well. It's up to the individual body corporate how they want to do it.
You mentioned about the charges, and we did receive a few questions in regarding that. So one of them was from a body corporate manager saying, we're a body corporate management company. We charge applicants a fee to supply the certificate, as it takes time for us to gather the information and complete the required information. And currently there is no cost to the body corporate to do this. The new prescribed fee set by the BCCM effective August 2025 is lower than the fee we charge and is also lower than the cost of production. As a result, we'll have to apply to the difference to the body corporates that we manage, meaning that the collective group of owners will have to pay for the sale of individual lots. It's expected that most body corporate agencies will have to do something similar. The SCA recommended that the fee be $220 per certificate. Why has the BCCM set the prescribed fee so low? Is there any information available on how they arrived at this figure? Why is there an expectation that body corporate service providers will provide a higher standard of documents for a lower fee than the current market rates?
Yeah, so the short answer is the BCCM office did not set the fee. It's a prescribed fee, which means it's in the legislation. It's set by the government. So if you've got an issue with the fee, you need to write to your local member of parliament, because they are the ones that can change prescribed fees. Our office has absolutely nothing to do with setting fees. So sorry, but that's the truth. We also look at it from a point of view of the form itself. Yeah, it's 10 pages. We know it's long. However, a lot of it only needs to be filled in once. If your bylaws don't change very often, cool, great. That makes it easy for you. Give them the bylaws. You don't have to change it. Your format plans, your regulation modules, your lot entitlements, those things almost never change. So you can download the form and fill out, I want to say, half of it today, and you will never have to change it. So don't look at it thinking, oh, it's a 10-page form, we're going to have to do it every time someone sells a lot. You don't. You can fill it out now and just have it saved, ready to go. Same thing for a lot of the levy information as well. I know Strata Max can auto-populate a lot of things for you. So I'm not a body corporate manager, and I won't claim to know everything that they do. But from what we've been told, things can be auto-populated, so it won't take too much time to do, especially if you have pre-saved copies. I get that there will still be work involved, and that this $84 fee may not cover it, but then body corporate managers in their contracts will have extra fees. They might have an hourly rate. You can charge that difference if it's in your contract. That's totally fine. Our office, we didn't set the $84 fee. We understand that it may not cover the work that's being done, but there are ways to mitigate the time that it takes to fill out these forms. If they don't want to do it, they can tell the committee to do it themselves. If they don't believe that they're recouping their costs for the work that's being put into it, sure, tell the committee to do it, because the body corporate is being paid the $84 fee, not the manager. We understand that. It's totally fine.
Okay, and we were also asked by an owner because the prescribed fee is $84, as you say, to apply to the body corporate certificate. Our body corporate manager has told us that they'll actually cost $200 for them to fill out the form. So can the full amount be passed on to the seller or purchaser instead of the body corporate owners having to pay for it?
No, and that for basically the same reasons of the PET applications that I gave before. It's a body corporate issue, so the body corporate pays that fee. The prescribed fee is for the seller to pay to the body corporate to get it. If the manager needs to charge more, that's in their contract with the body corporate as a whole.
Okay, excellent. All right. Well, thank you very much, Nathan. And thank you very much, Nikki, as well. That brings us pretty much up to the end of the session. So, Nathan, we might just go back to you and say any final words before we close out the session.
Please look at our website, call us or email us if you need to for any questions that we haven't covered today. That's what we do. It's what our info team's here for. So please reach out if you do need anything. We just launched our new Facebook page as well. So if you want to follow us on Facebook, Office of the Commissioner for Body Corporate and Community Management. Long title, I know. Search for it, give us a like, give us a follow. We're putting out lots of information on there. So please get involved with that.
Excellent. All right, that's wonderful. And Nikki?
Yeah, Facebook page is up and running. It's quite fun, and thank you everyone for the opportunity to be here. The only thing that I would say from a conciliator's perspective is that as much as I don't want to see anyone at conciliation, because I'd like you to be able to resolve things on your own and internally, conciliation does work. So if you do have a dispute and you do need assistance, it is a function that does work in most matters. So welcome to come along, and most people recommend conciliation too. So rather than going to that adjudication process, so use us if you need us, but work together where you can and use the info line as well.
Excellent. Thank you. Thank you both very much for the work you both and the team at the BCCM do. I think you do a fantastic service for everyone. I think Queensland's very lucky to have the Commissioner's office to call on, and you're always available, and we certainly send a lot of people that way that we're unable to assist to help at the time. So yeah, we really appreciate what you do, and we recognise what you're doing as well.
Thank you very much. Thanks for putting us on.
If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.